Yes. Hello. Good evening, everyone. Welcome to Everything Legal Lounge. Welcome to Everything Legal Lounge. For those that are just joining today or joining for the first time, my name is Chukwemeka Philip. I'm a Nigerian lawyer and the founder of E.L Everything Legal. The founder of E.L Everything Legal. Now, what we do at Everything Legal is simple. We help students optimize their performance in the bar exam and achieving success, a very high success rate in the bar exam. And a quick introduction of this program, Legal Lounge. Now, Legal Lounge is a very juicy opportunity that should be seized and utilized by all students, all aspirants to the bar. Now, it's a free live program geared towards enhancing success in the bar exam. And we do this simply by making topics or concepts for the courses in the Nigerian Law School simple, understandable, and applicable. Remember, I always stress on application of issues in the five courses. You'll be tested on application, and this is what we do here, right? Now, for the Legal Lounge, it's a free live platform to encourage students in the Nigerian Law School to render assistance, and of course, to ensure that you all excel in the bar exam. We kicked off last week, Saturday. It holds weekend, Saturday, 7 p.m. And we kicked off last week, Saturday. Now, the last program was a very powerful one. We introduced the course property law practice, right? We stressed on key concepts, key things that must be appreciated by students to excel in the bar exam for property law practice. And the good news is this, the live classes are saved in our platform. So do well to subscribe and go over them in case you fall under the category of students that have missed previous classes. Now, let's get to the agenda for today. For today, we would discuss and also demystify a particular topic in property law practice. Now, I don't know why, but students are always scared of mortgage in property law practice. Maybe it's because it seems abstract from other topics, or it has technical principles that students must not forget. Yes, yes, there are technical principles in mortgage that students must remember and take cognizance of. All right, so today we would, as we promised last week, today we will discuss mortgage in property law practice. And we'll bring a different dimension to mortgage so that you know why you as a student have been having problem with the topic mortgage and how to apply your understanding of mortgage in the bar exam. Remember, you are not just to read, you are to understand and apply this concept. You are tested on application of the concepts you've read in the bar exam. And it's important, it's a different thing altogether to apply. And that's our focus in our class. So let's get to it. Mortgage. Now, as I said last week, the problem students have in mortgage starts from the definition. Yes, the problem with mortgage starts from the definition. Students have not grabbed a great definition of mortgage. Yes, this is where the problem comes from the definition. A lot of students see mortgage as transfer of property, right? Transfer of property to collect a loan and basically giving another person possession of a property to service a loan, and upon repayment, you get back your property. I would want to correct that because that is where the problem or the issue in mortgage starts from. Now, let's listen, class. Mortgage is the transfer of interest in land. Mortgage is the transfer of interest in land. Mortgage is not the transfer of possession. It's possession that confuses students in understanding mortgage. And I repeat, mortgage is the transfer of interest in land. And let's go further to break this. Interest is simply the right of ownership of a land. Interest in land is title to land. The right of ownership, the right a person has over a land is what we know as interest in land. So mortgage is not the transfer of the possession of the land itself. Mortgage is the transfer of interest in land, the right over land, the entitlement to the land is transferred. I repeat, the right or the entitlement to land is transferred in mortgage. This is the concept of mortgage. It is the transfer of interest in land. The interest that can be transferred may be legal or equitable interest. I repeat, it may be legal or equitable interest. So for the last time, class, mortgage is the transfer of interest in land, not possession of the land. Now, the interest is used as a security for a loan subject to redemption. I repeat, mortgage is the transfer of interest in land to be used as a security for a loan subject to redemption. Now, interest is the right over the property, the right of ownership over the land. That is what is transferred temporarily to service a loan subject to redemption. Redemption means upon repayment of the loan, the interest is transferred back to the mortgagor. I repeat, upon repayment of the loan, the interest is transferred back to the mortgagor. This is the first step you should take as student in understanding and simplifying mortgage. And for the last time, I'll repeat, mortgage is the transfer of interest in land. It is the interest that is used as security for a loan, not the possession. That's why a person can use his land to create mortgage for two different people, right? Mr. A may use a property to obtain loan from Mr. B and obtain loan from Mr. C. The reason is this. In mortgage, it is the interest that is transferred and not possession. I repeat, it is the interest that is transferred and not possession. I need this to sink into your heads as students. Now, to further simplify this, I will take you back to a previous topic, sale of land. You learned sale of land before mortgage. At the contract stage in sale of land, there is something called exchange of contracts. Exchange of contracts simply means signing and swapping the contract of sale agreement, right? Now, at the point of exchange or after exchange, there is one implication you must not forget. And the implication is this. The mortgagor, not the mortgagor now, sorry, we are in sale of land, so it's vendor and purchaser. The vendor retains the legal interest while the purchaser obtains equitable interest. I repeat, after exchange of contracts at the point of signing and swapping the contract of sale, the vendor retains legal interest while the purchaser obtains equitable interest. Now, at that point, the purchaser can use that land to obtain a loan. Because the purchaser has acquired interest in the land, though not possession, He has no possession of the land at that point, but the purchaser has acquired interest in land. And this interest is known as equitable interest. The purchaser can enter into a mortgage agreement with that equitable interest and obtain a loan using that interest. So this is the first issue in mortgage. Mortgage involves the transfer of interest in land and not the possession of the land. I need you all to know this so that you can understand other concepts in mortgage. Having known the basic definition of mortgage, there are three things here: interest in land, legal or equitable. Number two, it's used as security for a loan. And number three, an option of redemption. Yes, mortgage is subject to redemption. Remember the saying, once a mortgage, always a mortgage. Remember the saying, once a mortgage, always a mortgage. Right? So mortgage is what is subject to redemption. The mortgagor can always redeem his interest upon repaying that loan. This is the basic concept, the basic idea behind mortgage. Number one, interest in land. Number two, security for a loan. And number three, redemption. So the interest in land is transferred to be used as a security for a loan, subject to redemption. Subject to redemption. So that is mortgage. That is mortgage. Now, let's get into other issues or other things in mortgage as a topic in property law practice. The transaction is called mortgage. I repeat, the transaction is called mortgage. The document or instrument to be executed, the document or instrument to be executed is known as the deed of mortgage. The document or instrument to be executed is known as the deed of mortgage. Number three, the parties. The parties to the mortgage transaction are the mortgagor and the mortgagee. The parties to the mortgage transactions are the mortgagor and the mortgagee. Now, number four, the preparation of the document. The deed of mortgage is prepared by the mortgagee's solicitor. I repeat, the deed of mortgage is prepared by the mortgagee's solicitor. So this is a basic background of what mortgage is all about. This is the basic background of what mortgage is all about. The next thing we'll get to is the parties. We'll discuss the parties quickly. Now, in mortgage, there are two parties, save for special circumstances where there might be three parties to a mortgage transaction. There are two parties, save for circumstances where there might be three parties to the mortgage transaction. Now, the two main parties in a mortgage are, number one, the mortgagor, and number two, the mortgagee. Number one, the mortgagor, and number two, the mortgagee. Now, the mortgagor is the party that transfers his interest in land to be used as a security for a loan. In other words, the mortgagor is the person seeking for loan, the person that borrows money using his interest as collateral. That is the mortgagor. The borrower is the mortgagor. Now, the other party is called the mortgagee. The mortgagee. The mortgagee is the lender, the person that gives money, the person that gives out loan is known as the mortgagee. So let's not confuse the parties. The mortgagor is the borrower, the mortgagee lends the money to the mortgagor. Now, there are special instances or circumstances where we have three parties in a mortgage transaction, and this is known as tripartite mortgage. Instead of two parties, we have three parties, right? Now, there are two instances where we'll have tripartite mortgage, where there will be three parties to a mortgage transaction. The first instance is where the transaction requires a guarantor. I repeat, the first instance is where the transaction requires a guarantor. A guarantor is a person that stands for the what? For the mortgagor, to ensure that the mortgagor will repay the loan. So there are certain mortgage transactions that will require a third party known as a guarantor, a person that will stand to guarantee repayment of the loan. Now, this third party is known as the guarantor. So where the mortgage transaction requires a guarantor, the third party is known as the guarantor, a person that stands and guarantees repayment of the loan by the mortgagor. That is the guarantor. Now, another instance of tripartite mortgage is where the mortgagor uses a property belonging to another person, belonging to a third party, to obtain a loan. I repeat, the second instance of tripartite mortgage is where the mortgagor uses the property of another person to obtain a loan. Now, in this circumstance, tripartite mortgage exists. There are three parties to the mortgage transaction. So the basic features of mortgage you must take home is this. Number one, it involves conveyance or transfer of interest in land and not possession of land. It involves conveyance or transfer of interest in land. And interest in land here is the right of ownership of land. The right of ownership of land is interest in land. Number two, the land is held only as a security to ensure repayment of the loan. The land transfer, that's the interest in land, is held as a security to ensure repayment of the loan. So the interest is not transferred perpetually. It is transferred to be held as a security to ensure repayment of the loan. This is another key feature you must remember in mortgage. Number three, the transaction is subject to redemption. Redemption means the mortgagor will always take back his interest after repaying the loan. After repayment of the loan, there is redemption. He takes back his interest. The interest is transferred back to the mortgagor. So this is known as redemption. These are the three basic features you must not forget about mortgage. Before we get to the types of mortgage, let's talk about capacity to create a mortgage. So there are certain persons that cannot enter a mortgage transaction. Number one is an infant. Yes, an infant has no capacity to create mortgage. An infant has no capacity to create mortgage. Number two, a person of unsound mind. A person of unsound mind. A person of unsound mind has no capacity to create mortgage. An infant has no capacity to create mortgage, and also a person of unsound mind has no capacity to create mortgage. Let's get to the types of mortgage. There are two types of mortgage. Number one, legal mortgage, and number two, equitable mortgage. I repeat, class. there are two types of mortgage. Mortgage are of two types. The first type is legal mortgage, and the second type is equitable mortgage. There is legal mortgage and there is equitable mortgage. And in this class, we would discuss how legal mortgage is created and also how equitable mortgage is created. So let's begin with legal mortgage. First, let's understand what legal mortgage is about. Legal mortgage is simply the transfer of legal interest in a land. Remember, the initial definition of mortgage I gave you all is that mortgage is the transfer of interest in land, not possession of land. Now, two types of interest can be transferred, legal or equitable. So for legal mortgage, where legal mortgage is created, what is transferred is legal interest. It involves the transfer of legal interest or the legal estates in land to be used, of course, as a security for a loan, subject to redemption. Class, legal mortgage involves the transfer of legal interest, legal estate in land to be used as a security for a loan. The next thing we will discuss is creation of legal mortgage. Remember, there are two types of mortgage. The first is legal mortgage, and the second is equitable mortgage. And for legal mortgage, I said it involves the transfer of legal interest, legal estate, the legal title in the land is transferred to create legal mortgage. Now, legal mortgage can be created in different ways. And the creation of legal mortgage depends on the property location, the property jurisdiction. I repeat, the creation of legal mortgage depends on the property jurisdiction or the location of the property. And for property law practice, the jurisdiction is divided into three. The jurisdiction is divided into three. The first one is the Conveyancing Act jurisdiction. That's CA states. It covers various states in Nigeria, states in the north, the northern part of Nigeria, the southeast, right? The south, except Edo and Delta State. So this is the Conveyancing Act jurisdiction. The second jurisdiction is known as PCL, Property and Conveyancing Law. And this PCL covers states in the old western region, that is the southwest, the Yoruba-speaking states, including Edo and Delta. Then the third location or the third jurisdiction is Lagos. Lagos is a jurisdiction on its own with regards to property law practice. Now, in creation of legal mortgage class, you must take cognizance of the jurisdiction involved or the location involved, whether it is CA, PCL, or Lagos. I repeat, whether it is CA, PCL, or Lagos. This is what you must take cognizance of in the creation of legal mortgage. So for creation of legal mortgage, we'll start with the first jurisdiction, legal mortgage in CA states. That is ways we can create legal mortgage under the Conveyancing Act. And under the Conveyancing Act, legal mortgage can be created in three ways. I repeat, class, under the Conveyancing Act, under the CA, legal mortgage can be created by three ways for CA states. The first one is by assignment of unexpired residue. The first one is by assignment of unexpired residue. The second one is by subdemise less than 1 day. The second one is by subdemise less than 1 day. And the third one is by charge. I repeat, there are three ways to create legal mortgage in CA states. The first one is by assignment of the unexpired residue. The second is by subdemise, less than 1 day. And the third is by charge. So let's start with the first one. Remember, class, we are still in CA states, CA location. The first one is by assignment of the unexpired residue. Assignment simply involves the transfer of the entire interest, including the reversionary interest of the mortgagor to the mortgagee. I repeat, assignment involves the transfer of the entire interest, including the reversionary interest of the mortgagor to the mortgagee. So where mortgage is created by assignment in CA states, the entirety of the interest of the mortgagor is transferred to the mortgagee. The entire interest, including the reversionary interest, is transferred to the mortgagee. This is the basic idea behind creating mortgage by assignment. It is fully called assignment of the unexpired residue. The entire interest. This is why I started with mortgage is transfer of interest and not possession, because it's from the understanding of this concept students begin to have problem in mortgage. I repeat, when mortgage is created by assignment, the entirety of the interest of the mortgagor is transferred to the mortgagee, including his reversionary interest. Now, for a math equation, assignment, the formula for creating legal mortgage by assignment would be unexpired interest plus reversionary interest equals to assignment. I repeat, unexpired interest plus reversionary interest equals to assignment. For the last time, unexpired interest plus reversionary interest equals to assignment. You can drop that in the comment section if you are following. Unexpired interest plus reversionary interest equals to assignment. So for assignment, when mortgage is created by assignment of the unexpired residue, the mortgagor transfers his unexpired interest plus his reversionary interest to the mortgagee. When this is transferred, it is used as, of course, security for a loan. So in this circumstance, mortgage is created by assignment. Now, another thing you must take note of is this. When mortgage is created by assignment, it must be created by deed. I repeat, it must be created by deed. For the last time, it must be created by deed. And it must not just be created by deed, the deed must be perfected. So for assignment, it's created by deed, and the deed must be perfected. Perfection simply means obtaining governor's consent, payment of stamp duty, and registration of the instrument. So basically, creation of mortgage by assignment involve the transfer of unexpired interest plus reversionary interest. Now, this transfer must be by deed, and the deed of mortgage must be perfected. Governor's consent must be obtained, stamp duty must be paid, and it must be registered at the land registry. Now, there are implications of creating legal mortgage by assignment. I repeat, there are implications of creating mortgage by assignment. Number one, when mortgage is created by assignment, it is very easy to exercise power of sale. I repeat, One implication of creating mortgage by assignment is that the exercise of power of sale becomes easy because the entire unexpired interest is transferred to the mortgagee. And where there is default, the mortgagee can easily exercise his power of sale. I would come to the concept of power of sale in this class. Now, the second implication is known as privity of contracts and privity of estates. The second implication of creating legal mortgage by assignment is known as privity of contracts and privity of estates. What this simply means is when mortgage is created by assignment, I repeat, when mortgage is created by assignment, the covenant the mortgagor has with the state government is transferred to the mortgagee. For the last time, when mortgage is created by assignment, the covenant the mortgagor has with the state government is transferred to the mortgagee. There are various examples of this covenant. One of the covenants is payment of ground rent. Now, ground rent is a rent that is paid on the bare land and it's paid directly to the state. It's not paid for occupation or for occupation of the land. It is paid on the bare land and it is paid directly to the state. So the covenant or the agreement to pay ground rent would be transferred to the mortgagee when mortgage is created by assignment, because this agreement, this covenant already exists in the head list. That is the covenant between the mortgagor and the state government. So when mortgage is created by assignment, the principle of privity of estate and privity of contract implies that the covenant the mortgagor has with the government is transferred to the mortgagee. Example, payment of ground rent. It is the duty of the owner of the land, that's the mortgagor, to pay ground rent to the state. Now, where mortgage is created by assignment by virtue of privity of contract and privity of estate, this covenant, these obligations between the mortgagor and the state is transferred to the mortgagee. So these are the implications of creating legal mortgage by assignment. By assignment. Now, the second mode of creating legal mortgage in C estate is by subdemise less than 1 day. Second mode of creating legal mortgage in C estate is by subdemise less than 1 day. By subdemise less than 1 day. Now, this is the concept of subdemise, and I want you all to understand this. In assignment, the entire unexpired interest is transferred to the mortgagee. I repeat, where mortgage is created by assignment, the entirety of the interest is transferred to the mortgagee. But that is not the case with subdemise. Now, for subdemise, the mortgagor does not transfer the entire interest. The mortgagor must retain reversionary interest to himself. I would repeat this again. When mortgage is created by subdemise, the mortgagor, that's the person looking for loan, does not transfer the entirety of his interest. The mortgagor retains interest to himself. He transfers part of his interest and retains some part to himself. Now, the part retained is known as reversionary interest. The mortgagor retains reversionary interest in creating mortgage by subdemise. This is what you must know to distinguish assignment from subdemise. For the last time, in assignment, everything is transferred. The entire unexpired residue is transferred to the mortgagee. But for subdemise, the mortgagor retains certain interest to himself. And this interest retained is known as reversionary interest. He transfers legal interest but retains reversionary interest to himself. So this is the basic idea behind creation of mortgage by subdemise. And that's why it's fully called by subdemise less than 1 day. The position of the law is that the mortgagor must hold at least 1 day of his interest to himself. He must not transfer everything to the mortgagee. Using as a math equation to understand creation of mortgage. For subdemise, the math equation is this: legal interest minus reversionary interest equals to subdemise. You can drop that in the comments. I repeat again: legal interest minus reversionary interest equals to subdemise. So for assignments, unexpired interest plus reversionary interest equals assignment. But for subdemise, legal interest minus reversionary interest equals to subdemise. So for subdemise, the mortgagor retains interest to himself by at least 1 day. That is why it's known as subdemise less than 1 day. The mortgagor must retain at least an interest of 1 day to himself. And this interest is known as reversionary interest. Now, let's get to the implications of creating legal mortgage by subdemise in CA states. Number one, first, you must know where legal mortgage is created by subdemise. It must also be by deed, and the deed must be perfected, consent, stamping, and registration. Now, to the implications. Number one, the first implication is this: there is no privity of estate or privity of contracts. There is no privity of estate or privity of contract. What this means is the obligations between the mortgagor and the state government, for example, payment of ground rent, tenement rates, and all that. These are the obligations the mortgagor owes the state. So the obligations of between the mortgagor and the state government remains with the mortgagor. Those obligations are not transferred to the mortgagee. Where mortgage is created by subdemise, there is no privity of estate or privity of contract. These obligations owed to the state by the mortgagor remains with the mortgagor. So where mortgage is created by subdemise, the mortgagor still has the obligation to pay ground rent, tenement rates, and all covenants he has with the state government. The principle of privity of estate and privity of contract will not apply here. So this is the second thing you must not forget about creation of mortgage by subdemise. Number two implication is this: where mortgage is created by subdemise, it is difficult to exercise power of sale. It is difficult to exercise power of sale. In exercising power of sale, the mortgagee rather, cannot sell the property of the mortgagor in default because he has no complete interest. The mortgagor retains reversionary interest, and by that, the mortgagee cannot just alienate, cannot just sell the property in exercising power of sale because of that reversionary interest retained by the mortgagor. For this to happen, the mortgagee must insert remedial devices to exercise power of sale. Remedial devices are declaration of trust and power of attorney. Remedial devices again are declaration of trust and power of attorney. Yes. So this is what is obtainable when mortgage is created by subdemise. Now let's get to the third mode of creation of mortgage in CA states. First, we discuss assignment, And I said assignment involved the transfer of the entire unexpired interest, including reversionary interest. Now, for subdemise, it involved the transfer of legal interest, but the mortgagor retains reversionary interest. This is the second mode of creation of mortgage in CA state. Now, for the third mode of creating mortgage in CA state is known as charge. It's known as charge. So mortgage could be created by charge and is fully called charge by deed expressed to be by way of legal mortgage. I repeat, charge by deed expressed to be by way of legal mortgage. This is the third mode of creating legal mortgage in CA states, by charge. I need you all to know this. Charge involves an appropriation of a property. I repeat, charge involves appropriation of a property. Appropriation means the land itself is encumbered, the land is nailed, the land is attached to that debt. When mortgage is created by charge, it involves the appropriation of a property to the debt. In other words, the land itself is nailed to the loan. The land is encumbered. The land is attached to the loan. Listen, class. When mortgage is created by charge, interest is not transferred. I repeat, interest is not transferred. It involves appropriation of a property subject to what? To a loan. This property is attached. It is nailed. It is encumbered. It is joined with the loan. And the property is not free from restriction until that debt is settled. So as long as the debt lasts, the property, there is a charge, there's an encumbrance, there's a restriction on the property. The property is attached, is joined with that loan, and until the loan is repaid, the property is not free from that attachment. Listen, when mortgage is created by charge, there is no transfer of interest. Legal interest is not transferred. Even equitable interest is not transferred. What happens here is the property is attached to the loan and a deed is executed. Now, in the deed, it will be stated that where the mortgagor fails to repay the loan, the property can be used to settle the debt. That is, the mortgagee has rights to take over the property, sell the property, foreclose, and all that, all the rights applicable to a mortgagee. We will get to that. But what you must take home from this class today is that where legal mortgage is created by charge, no interest is transferred. A deed is executed, and the purpose of that deed is to attach a property to the debt. Until the debt is settled, the property is not free from that attachment. This attachment is called encumbrance, an appropriation on a property. And when there is failure to repay the debt, the mortgagee can go after the property to recover the loan and interest. This is the basic idea behind creation of mortgage by charge. And the rationale behind charge, it was introduced to mitigate the hardship of creating legal mortgage by assignment and subdemise. That is the long process of transferring legal interest and also reconveyance of interest. So where mortgage is created by charge, there is no transfer of legal interest and the interest is not reconveyed. The deed is executed to attach the property, to appropriate the property to that debt. And until the loan is settled, the property is not free from restriction, is not free from the encumbrance. This is known as charge. Where mortgage is created by charge, interest is not transferred, but it is by deed. A deed is executed. and it has all features of a legal mortgage. All the features of a legal mortgage are available under section 110 of the PCL applies to charge. The only difference is that where mortgage is created by charge, interest is not transferred. It does not involve the transfer of interest. It is simply an appropriation of a property. The property is appropriated. The property is nailed to the debt. And the property will not be free from this appropriation until the debt is settled, until the loan is discharged. This is known as charge. Another thing you must take note of is charge is created by deed. Where legal mortgage is created by charge, it is by deed. A deed is executed and also perfected. However, it is not discharged by deed. It is discharged by a document known as statutory receipt. A legal charge is not discharged by deed. It is discharged by statutory receipt. This is the basic idea behind creation of mortgage by charge. It reduces the burden of executing a deed to create and also executing another deed to discharge the mortgage. Where there is a deed to create mortgage by charge, there will be no need to discharge it by deed. It is simply discharged by statutory receipts. So this is the idea behind creation of mortgage by charge. Remember, legal interest is not transferred. No interest is transferred. It involves an encumbrance, appropriation, attachment of a property to the debt until it is settled. So these are the three ways of creating mortgage in CA states. The first one is by assignment of the unexpired residue. The second one is by subdemise, less than 1 day. And the third mode is by charge. Charge by deed expressed to be by way of legal mortgage. So this settles creation of legal mortgage in CA states, Conveyancing Act states. Let's move to the second one, the PCL states, Property and Conveyancing Law states. Now, for the PCL states, the ways of creating mortgage are number one, by subdemise, and number two, by charge. I repeat, number one, by subdemise, and number two, by charge. Now, for subdemise in the PCL states, it's basically the same concept we learned in CA states, but there is a catch, there is a difference which you must know. Now, where mortgage is created by subdemise in PCL states, it involves transfer of legal interest, but the mortgagor retains reversionary interest of at least 1 day. Remember, it's fully called by subdemise, less than 1 day. It involves transfer of legal interest, but the mortgagor retains reversionary interest by at least 1 day. So this is basically creation of mortgage by subdemise. The entirety of the mortgagor's interest is not transferred to the mortgagee. The mortgagor retains reversionary interest by at least 1 day. The same implication applies where mortgage is created by subdemise in PCL states. Number one, the concept or the principle of privity of contract and privity of estate will not apply. This means that the obligations between the mortgagor and the state government remains with the mortgagor. The obligation is not transferred to the mortgagee. Where mortgage is created by subdemise, the obligation between the mortgagor and the state remains with the mortgagor. Example, payment of ground rent remains with the mortgagor. It is not transferred to the mortgagee. Now, the second one is on the exercise of power of sale. and I want you to take this home. For PCL states, where mortgage is created by subdemise, the mortgagee can easily exercise power of sale, irrespective of the reversionary interest of the mortgagor. I repeat, where mortgage is created by subdemise, in PCL, the mortgagee can easily exercise power of sale, even with the reversionary interest held by the mortgagor. This means that in PCL states, there is no requirement to insert remedial devices in exercising power of sale where mortgage is created by subdemise. This is the basic difference between subdemise in CA states and subdemise in PCL states. In the CA states, for mortgage created by subdemise, there is need to insert remedial devices to alienate the reversionary interest of the mortgagor. However, in PCL states, there is no requirement of inserting the remedial devices. That is, the mortgagee can exercise power of sale without inserting declaration of trust and power of attorney, even with the fact that mortgage is created by subdemise. This was empowered, the empowerment came from section 112 of the PCL. It allows the mortgagee to alienate the reversionary interest of the mortgagor without remedial devices where mortgage is created by subdemise. This opportunity applies only to the PCL states and not the CA states. So this is why you must be careful in identifying the location in discussing or answering a question on mortgage. The state is very important to take cognizance of. Now, the second mode of creation of mortgage in PCL states is by charge. Now, charge applies in PCL. Charge by deed expressed to be by way of legal mortgage. And remember what I said about charge. For charge, the interest is not transferred. Charge involves appropriation of the property. The property is encumbered. The property is attached. The property is restricted until that debt is settled. So this is the basic idea behind creation of mortgage by charge. Where legal mortgage is created by charge, all the features of legal mortgage apply, except one thing. And the one thing is this: legal interest is not transferred. It is created by deed. It has all features of a legal mortgage, but legal interest is not transferred. Legal interest is not transferred. In fact, no interest is transferred when mortgage is created by charge. It does not involve the transfer of interest. The deed only shows a restriction on the property, an encumbrance. The property is appropriated until the debt, the loan, is settled. So this is basically creation of mortgage in PCL states. Remember, for subdemise in PCL states, there is no need to insert remedial devices. Section 112 makes it easy to exercise power of sale without inserting remedial devices in PCL states where mortgage is created by subdemise. But this option is not available in CA states. For CA states, the mortgagee must insert remedial devices in order to exercise power of sale. Yes, please don't forget the issue of remedial devices in subdemise. It's very important. Now let's get to the third location in creation of legal mortgage. Remember, legal mortgage. Now, for the third location, it is Lagos. The third location is Lagos, creation of legal mortgage in Lagos State. And for Lagos State, the first thing you must take note of is the nature of interest. I repeat, the first thing you must take note of is the nature of interest. We are very lucky that we had an introductory class in property law practice last week, and the replay is available on this channel. So do well to go back to it. On our last class, we delved into the concept of nature of interest, and I taught you all how to apply your knowledge of nature of interest in different transactions. It is very important. The two natures of interest we discussed last week are the leasehold interest and freehold interest. And if you remember, I said you identify leasehold interest where the land is covered by certificate of occupancy. You identify leasehold interest where the land is covered by certificate of occupancy. Now, where the land is not covered by certificate of occupancy, where the land is not covered by certificate of occupancy, the interest is freehold interest. This is what you should take home to identify these things in a scenario. To get to the point of legal mortgage in Lagos, you must first take cognizance of the nature of interest, whether the land is covered by certificate of occupancy or not. Now, where the nature of interest is freehold interest, that is, the land is not covered by certificate of occupancy. Where the land is not covered by certificate of occupancy in Lagos, legal mortgage can be created by demise and charge. I repeat, where the nature of interest is freehold interest, the land is not covered by certificate of occupancy in Lagos State, legal mortgage is created by demise or by charge. I repeat, by demise or by charge. Now, where the nature of interest is leasehold interest, that is, the land in question is covered by certificate of occupancy. Legal mortgage is created by subdemise or by charge. I repeat, in Lagos, where the nature of interest is leasehold interest, legal mortgage is created by subdemise or by charge. Please, class, take note of this. For Lagos, you must take cognizance of the nature of interest. You must take cognizance of the nature of interest. Freehold interest, we create legal mortgage by demise. Leasehold interest, we create legal mortgage by subdemise. Now, legal mortgage can be created by charge in Lagos, and charge applies both ways. It applies for both freehold interest and leasehold interest. Freehold interest and leasehold interest. So this is the basic principle of creation of legal mortgage in Lagos. So you can see section 15 and section 16 of the Mortgage and Property Law of Lagos 2010. Right? Section 15 talks about demise, where the nature of interest is freehold interest. Legal mortgage is created by demise. Now, section 16 talks about subdemise, where the nature of interest is leasehold interest. That is, the land is covered by certificate of occupancy. Legal mortgage in Lagos is created by subdemise. Now, for charge applies both ways. Legal mortgage is generally created by charge, both in CA, PCL, and in Lagos. So the second issue is what we've finally demystified, the issue of creation of mortgage. The issue of creation of mortgage. It solely depends on the location, CA, PCL, and Lagos. That is for legal mortgage. Now let's get to the second type of mortgage. The second type of mortgage is known as equitable mortgage. The second type of mortgage is equitable mortgage. Equitable mortgage. I said something critical about legal mortgage. Legal mortgage must be by deed, must be created by deed, and the deed must be perfected. Governor's consent, stamp duties, and registration of the instrument. Legal mortgage must be by deed, and the deed must be perfected. Consent, stamping, and registration. When the mortgage is by deed and it is not perfected, anything short of creation of mortgage by deed and absence of perfection of the deed results in equitable mortgage. Yes, equitable mortgage is anything that is not legal mortgage. Where the mortgage is not legal mortgage, it falls under equitable mortgage. Yes, because equity recognizes the existence of the transaction, even when the deed is not perfected or even when the deed is not executed. Equity recognizes the existence of a transaction where there's an intention to create one, right? Now, this is the idea behind equitable mortgage. And for your knowledge, anything short of legal mortgage is equitable mortgage. And I've given you the basic ingredients of legal mortgage. It must be by deed. A deed must be executed, and we not just stop there. The deed must be perfected. Consent, stamping, and registration. Anything short of this results in equitable mortgage. Now, let's get to the modes of creation of equitable mortgage. Equitable mortgage is straightforward. You don't need to take cognizance of whether it's CA, PCL, or Lagos. Equitable mortgage applies all round. Now, the basic mode of creation of legal mortgage is number one, by deposit of the title documents. Number one, by deposit of the title document with an intention to create mortgage. Deposit of title document with an intention to create mortgage. Deposit of title document with an intention to create mortgage. You can see the case of Bond, B-O-N, against Akintoye. Deposit of what? Title document with an intention to create mortgage. So where the mortgagor deposits his deed, title documents with the mortgagee with an intention to be used as security for the loan, an equitable mortgage is created. That is one mode. Number two, an imperfect deed of legal mortgage. Number two, an imperfect deed of legal mortgage. When a legal mortgage is created by deed and the deed is not perfected, governor's consent, stamp duties, registration, where these three things are absent in the deed of legal mortgage, that mortgage becomes an equitable mortgage. So an imperfect deed of legal mortgage results to equitable mortgage. Number three, an agreement to create legal mortgage. A mere agreement to create legal mortgage acts as an equitable mortgage. A mere agreement to create legal mortgage acts as equitable mortgage. And finally, there is equitable charge. Yes, equitable charge. So these are the ways of creating equitable mortgage. It is very straightforward. Deed is not required. Deed is not required for equitable mortgage, but for legal mortgage, deed is adequately required. And it is not just required, the deed must be perfected. The deed is required and the deed must be perfected. So this is the basic difference between legal mortgage and equitable mortgage. Now, to criticize both, that is advantages and disadvantages between legal and equitable mortgage. Now, legal mortgage has advantages over equitable mortgage, and also equitable mortgage has advantages over legal mortgage. For legal mortgage, remember it is created by deed, right? And the deed is perfected and all that. So one advantage of legal mortgage is it is more secured. It is secured from fraud. Yes, it is more secured. It's secured from fraud, number one. Number two, it's very easy to enforce. There is a deed, and the deed is perfected, registered, known to law, right? So legal mortgage is easy to enforce. Number three, priority. A legal mortgage ranks higher in priority. Yes. So where there's a legal mortgage and there's an equitable mortgage, the legal mortgage will be settled first before the equitable mortgage, because legal mortgage always rank higher in priority. Yes. So these are the advantages. Now, finally, the terms. One advantage of legal mortgage is that there is clarity of terms. The terms of the transaction is clearly embedded in the deed of mortgage. All the intention of the parties are known by virtue of creating a deed of legal mortgage. So this is the advantage legal mortgage has over equitable mortgage. Now, equitable mortgage has advantage over legal mortgage too. One advantage equitable mortgage has is, number one, it is easier to what? To create. Yes, it is very easy to create. It is simple to draft. A simple agreement. Mere deposit of title deed creates legal equitable mortgage rather. Number two, it is easy to discharge. Yes, it is easy to discharge. For equitable mortgage, is discharged by a simple receipt. There is no need to execute a deed to discharge equitable mortgage. Equitable mortgage is discharged by simple receipt. Simple receipt means transaction receipt. Just like when you make a transfer with your bank app, the receipt, the evidence of repayment of the loan. That is what is required to discharge equitable mortgage. So it is easy to create, it is easy to discharge. And number three, there is no privity of contracts. Yes, the obligations are not transferred to the mortgagee. So this is a comparison between legal and equitable mortgage. And as students, when asked to do this, I believe you'll be very able to do this comparison. It is straightforward. Yes. So at this point, we are done with the issue of creation of mortgage. Now, let's get to some technical terminologies or concepts in mortgage that students always confuse. And there are three. I would base our discussion on these three so that you understand these three different concepts and you are able to apply this concept in scenario. In mortgage, students confuse three concepts. One is the concept of up stamping. Yes, up stamping. The second one is successive mortgage. The second one is successive mortgage. And then the third one is what? Consolidation. These three terms, these three terminologies are often confused by students. There's a misconception in these terminologies. Upstamping, consolidation, and successive mortgage. So we would deal with this concept now, and then I would head to basic issues on rights of the mortgagee and rights of the mortgagor. And I believe we can end our class at that point. Now, let's start with the first concept or first terminology that students find difficult. Up stamping. Up stamping. You see, in learning, when you come across a word or a term in law or English or any other course, the first thing you should do is to break down the understanding of that word and then get it as a concept before you are able to apply in a scenario. So basically, there is the first concept known as up stamping. Up stamping. Now, before we talk about up stamping, let's talk about stamping. What does stamping entails, or what does stamping involve? Stamping simply means payment of stamp duty. Stamp duty is a tax paid on property transaction. One of the tax paid on transaction is known as stamp duty, right? So stamping, or the concept of stamping, simply means payment of stamp duty. Payment of stamp duty. Now, this leads us to the broader concept of up stamping. We've known stamping as payment of stamp duty. Generally, stamping means payment of stamp duty. Now, this leads us to the concept of up stamping. Up stamping applies where a prior legal mortgage has been created. Up stamping applies where a prior legal mortgage has been created. And the mortgagor seeks for an additional loan from the same mortgagee. I repeat, the mortgagor seeks additional loan from the same mortgagee. There is existence of a prior legal mortgage, and the mortgagor seeks additional loan from the same mortgagee using the same property as security. Now, for up stamping, the principle is this: where there is a prior legal mortgage and the same mortgagor seeks an additional loan, there is no requirement of obtaining governor's consent on the additional loan. The mortgagor is simply to pay additional stamp duty. I repeat, what is to be paid is additional stamp duty on the subsequent loan. Mr. A is a mortgagor. He uses his property Z, to obtain loan from Mr. B. A legal mortgage is created. Now, Mr. A needs additional loan of, let's say, 200 million naira using the same property. What happens at this point is this: for the second or additional loan, there is no requirement of governor's consent. What is to be done is to pay additional stamp duty on the additional loan. That is why it is called up stamping. Payment of additional stamp duty without obtaining governor's consent. But this can only be done where it involves the same mortgagor, the same mortgagee, and the same security. I repeat, the same mortgagor, the same mortgagee, the same security. So you can write this as factors pointing to up stamping. Number one, legal mortgage. Number one, prior legal mortgage. Number two, the same mortgagor. Number three, the same mortgagee. Number four, the same security. And number five, additional loan. Prior legal mortgage, the same mortgagor, the same mortgagee, the same security, additional loan. So these are the factors pointing to up stamping. And the principle of up stamping, as established in Owoni Boys Technical Service Limited against Union Bank of Nigeria Limited, is to the effect that there is no requirement for governor's consent on the additional loan. What is to be done is to pay additional stamp duty on the additional loan. And this additional stamp duty, or payment of additional stamp duty on the additional loan, is known as up stamping. So this is the first concept, up stamping. The second concept or terminology that students find difficult is consolidation. So first, we dealt with up stamping, and second, we have to deal with now is consolidation. For consolidation, the word consolidate simply means, in its ordinary meaning, consolidation means to join two things together. Yes. When something is consolidated, it means it is joined together. you bring two things together into one. That is consolidation. Please, the basic meaning of consolidation is bringing two things together. Now, let's get to the legal meaning and how consolidation affects mortgage. The meaning of consolidation in mortgage. Yes, the basic meaning would help you appreciate consolidation in mortgage. The basic meaning means joining two things together. That is consolidation. In mortgage, consolidation applies or will occur where a mortgagor uses two different properties. I repeat, a mortgagor uses two different properties as security for a loan. A mortgagor uses two different properties as security for a loan. The basic example is this: Mr. Amadi is a mortgagor and First Bank is the mortgagee. Now, Mr. Amadi has a property in Lagos. Mr. Amadi also have another one in Oyo State. Mr. Amadi needs a loan of 500 million. The property in Lagos worth 300 million. He uses that property to obtain 300 million from First Bank. Now, the property in Oyo State worth 200 million. The same man uses the property in Oyo State to obtain additional 200 million from First Bank. The mortgagor uses two different securities to service the loan. This is where consolidation will come to play. Now, what happens in consolidation or the joining that occurs here is this. The mortgagee, First Bank PLC, joins the two securities together, both the mortgage of Lagos and the mortgage in Oyo State, joins the property together, such that Amadi cannot redeem the property in Lagos without redeeming the property in Oyo State. And Amadi cannot redeem the property in Oyo State without redeeming the property in Lagos State. This is the basic idea behind consolidation, where there are two different securities and the mortgagee brings them together, such that the mortgagor cannot redeem one without redeeming the other. In redemption, he must redeem all at once. This is consolidation of mortgage. And for the pointers of factors leading to consolidation, number one, the same mortgagor. Listen, class, you can write. Number one, the same mortgagor. Number two, the same mortgagee. Number one, the same mortgagor. Number two, the same mortgagee. And number three, different security. I'll repeat. Number one, the same mortgagor. Number two, the same mortgagee. Number three, different security. Different security. This is what you should take home. Consolidation, the same mortgagor, the same mortgagee, different security. So the mortgage is joined together such that the mortgagor cannot redeem one without redeeming the other. This is the idea behind consolidation. Now, class, you must know this. Consolidation is restricted both under the Conveyancing Act and the PCL. Yes, there is a restriction on consolidation. The law restricts consolidation. Now, for parties to consolidate, it must be expressly stated in the agreement that's the deed of mortgage, that the parties have consented to consolidation. Listen carefully. There is a restriction on consolidation. Consolidation is not automatic, right? Pursuant to Section 17, Section 28, and Section 115 of the CA and PCL, respectively, they place a restriction on consolidation. And for parties to consolidate, it must be expressly stated that the restriction placed on consolidation shall not apply to them. This is the basic idea behind consolidation. Please, consolidation is restricted. And for parties to consolidate, it must be expressly consented and stated in the deed of mortgage. That's why there's a covenant known as covenant as to consolidation. The covenant that states that the restriction on right of parties to consolidate will not apply to them. So that is the basic issue in consolidation. Remember, the same mortgagor, the same mortgagee, different security. Now let's get to the third one, successive mortgage. The third concept, successive mortgage. Successive mortgage. Yes, successive mortgage. It's one of the concepts in mortgage that you must take cognizance of as students and understand the idea behind successive mortgage. Successive mortgage basically applies where there is a prior legal mortgage. I repeat, there is a prior legal mortgage and the same security is used to what? To create another legal mortgage. Successive mortgage occurs where there is a prior legal mortgage and the same security is used to create another legal mortgage. The existence of two legal mortgage, successive legal mortgage. There is one legal mortgage and that same security is used to create another legal mortgage. This is the idea behind successive mortgage. Listen, class. Now, for successive mortgage, the mortgagor, Amadi, has a property in Abuja worth 1 billion naira. Now, Amadi uses that property to obtain a loan of 200 million from GT Bank. I repeat, Amadi uses that property to obtain a loan of 200 million from GT Bank. The same Amadi uses that same property worth 1 billion to obtain another loan of 500 million from Access Bank. Listen again. Amadi uses the property worth 1 billion to obtain a loan of 200 million from GT Bank. The first legal mortgage is created. The same Amadi uses that property in Abuja worth 1 billion. The value of the property is 1 billion to create a mortgage and obtain loan of 500 million from Access Bank PLC. This is where the concept of successive mortgage occurs, where the same security is used to create mortgage in two different transactions. Yes. Now, to drive this home, I want you to write basic factors pointing to successive mortgage. Number one, listen carefully. Number one, the same mortgagor. Number one, the same mortgagor. Number two, the same security. Number two, the same security. And number three, different mortgagees. Number one, the same mortgagor. Number two, the same security. Number three, different mortgagees. So please, the same mortgagor uses the same property to obtain loan from two different people, two different persons, two different parties. This is the idea, the rationale behind successive mortgage. And you must know this for successive mortgage. Number one, it must be a legal mortgage. Yes. Please. Number one, for successive mortgage to occur, for successive mortgage to work, it must be a legal mortgage. It must be a legal mortgage. And number two, the first one I said, it must be a legal mortgage. First one I said, it must be a legal mortgage. And then the security must be valuable enough to accommodate a subsequent loan. I repeat, the security must be valuable enough to accommodate a subsequent loan. The first one, it must be a legal mortgage. The second, the security must be valuable enough to accommodate an additional loan, the second loan. So take note of this. You cannot use a property of, let's say, 200 million to obtain a property worth 200 million to obtain loan of 100 million from First Bank, another loan of 200 million from Access Bank. That will not work because the property, the security is not valuable enough to accommodate the subsequent loan. Yes, the security must be valuable enough to accommodate the subsequent loan. Now, let me run down the three concepts or three terminologies I explained now. I started with upstamping, went into consolidation, and ended with successive mortgage. Now, for upstamping, take these keywords. Number one, legal mortgage. Number one, prior legal mortgage. Number two, the same mortgagor. Number three, the same mortgagee. Number four, the same security. The same mortgagor, the same mortgagee, the same security, additional loan. So these are the pointers to upstamping. Prior legal mortgage, the same mortgagor, the same mortgagee, the same security, and additional loan. So when you see these elements in a scenario, it's pointing towards upstamping. And remember, what is to be done is to pay additional stamp duty on the subsequent loan. There is no requirement for governor's consent. Owoni Boys Technical Service Limited against Union Bank of Nigeria. Now, the second I went into was consolidation. And for consolidation, take these factors. Number one, the same mortgagor. Number two, the same mortgagee. And then number three, different security. Number three, different securities. Different securities. So there are two different securities used to obtain loan by the same persons. This is pointing to consolidation. What will be need to be done is to join them together so that the mortgagor don't redeem one without redeeming the other. Yes. And remember, consolidation is restricted. To do this, it must be expressly stated that the parties have the right, have agreed or consented to consolidation. So for consolidation again, the same mortgagor, the same mortgagee, different security. Now the third one is successive mortgage. And I said take these factors or these pointers to successive mortgage. Number one, the same mortgagor. Number two, the same security. And number three, different mortgagee. The same mortgagor, the same security, different mortgagees. So where there are two different mortgagees, two different people giving loan, it's pointing towards successive mortgage. So what is different in successive mortgage is what? The mortgagee, different mortgagee. Now for consolidation is different securities, while for upstamping, everything is the same. I'll repeat. For upstamping, everything is the same mortgagor, the same security, the same mortgagee. However, for consolidation, different security, different security. While for successive mortgage, different mortgagee. The mortgagee is different. Consolidation, security is different. Upstamping, everything is the same. Now, I believe we're done with this concept. Let's get to the issue of rights. Yes, in fact, this is a technical aspect in mortgage, and there will be a lot of questions on rights of parties to the mortgage transaction. There are two basic parties, the mortgagee and the mortgagor. So for the right of parties, we'll start first with the right of the mortgagee. When we deal extensively with the right of the mortgagee, and most of the principles are on the right of the mortgagee. After dealing with the right of the mortgagee, we'll get to the right of the mortgagor, right of the mortgagee. So to re-emphasize, the mortgagee is the lender, the person that gives loan, the person that gives loan to people, right? In layman context, please don't write this in exam, the person that gives loan. No. So the mortgagee is the lender, right? The person giving loan, the giver of the loan is known as the mortgagee. And there are various rights the mortgagee has in mortgage transaction. And it's very important. You must know them for the exams. I would give a long list of the rights and would explain some important rights of the mortgagee. So number one, the mortgagee has right to take possession. Listen, the mortgagee has rights to take possession. You see initially why I said mortgage is not the transfer of possession, it's the transfer of interest in land. The right of ownership in land is transferred, not possession. This is where the bulk of the confusion in mortgage starts from the definition. So the first right of mortgagee is the right to take possession. So there is also foreclosure. Foreclosure, there's a right to appoint a receiver, right to appoint a receiver, there's the right to sell, there's the right to sell, right? And consolidation, possession of title documents, and all that. So these are basically rights. And action, he has right of action in court. Yes, right of action in court to recover the loan and interest. So these are the rights of the mortgagee, right of the mortgagee. In explanation, I will base on basic ones, especially I will spend more time in the right to sell because they are critical principles in right to sell, where we discuss power of sale. That's where a lot of technicalities are in right of mortgagee. The right to sell is very important. This does not mean you should not read other ones, but the right to sell, power of sale, questions arising from right to sell are always a go-to in mortgage transaction. But that will be the last. Let's begin with the right to take possession. Yes, we'll start with right to take possession. The mortgagee has right to take possession, and this right is immediate upon creation of mortgage. This right is immediate upon creation of mortgage, legal mortgage. When the legal mortgage is created, the mortgagee has the right to take possession. The mortgagee has a right to take possession. The right is immediate. The right to take possession is immediate. For the last time class, the right to take possession is immediate. Immediate. The mortgagee cannot be liable for trespass when mortgage is created with respect to a property. Because upon creation of mortgage, the mortgagee has right to take possession. It is immediate. And see the case of Smith and Hughes, which is spelled Hugs. It is immediate. The right to take possession is immediate. But listen, class, there is something you must know. The fact that the mortgagee has right to take possession does not mean it is advisable for the mortgagee to take possession. This is where application comes to play. The mortgagee has right to take possession, yes. Immediate, yes. He can even exercise force in taking possession, yes. And it will be an exception to self-help, as in the case of the Ojukwu case, Ojukwu and Governor of Lagos, right? Yes. Yes, all these are true. But I need you to think. The right to take possession is immediate. It does not mean it is advisable. So for a question on possession, you should be careful. Yes, the mortgagee has rights to take possession, but it is not advisable. We will not advise the mortgagee to take possession. The reason is this: where the mortgagee takes possession of the property, the mortgagee is liable to what? To strict account. The mortgagee would account for every profit made on the property. Yes, this is why it is not advisable for the mortgagee to take possession. The mortgagee, upon taking possession, is liable to account for every profit made on the property. Number two, the mortgagee is liable for repairs. The mortgagee becomes liable for repairs. So please, yes, the mortgagee has right to take possession, but it is not advisable to take possession because of one, strict accountability, and number two, repair. Repair. The mortgagee will be liable for repairs. You see the case of Sandon and Hopper. Take cognizance of this. You would not advise a mortgagee to take possession. Please. It is appropriate, it is lawful, it is legal, it is acceptable, but it is not advisable. When you're answering this kind of question, you write it is not advisable. Yes, it is appropriate, but not advisable, because where the mortgagee takes possession, the mortgagee becomes liable to render account for every profit made and liable for repairs. So this is why you would advise the mortgagee against taking possession. So we've dealt with possession. Possession is straightforward. The next is right to appoint a receiver. Yes, the mortgagee has right to appoint a receiver. A receiver is an uninterested third party who manages the security for the purpose of what? Of making profits to settle the loan and interest. So a receiver is a third party appointed to take possession of the property, manage the property, make profits from the property, and use the profit to settle the loan and interest. Upon this settlement, the property is given back to the mortgagor. Yes. So, right to appoint a receiver applies to the mortgagee. The mortgagee can appoint a receiver who manages the property with the purpose of making profits. The purpose of appointing a receiver is to make profit on the property and use that profit to settle the loan and interest. Example of making profit is collecting rent from the property. A receiver may take over the property, lease the property out, collect rent from the property. Rent is profit on the property, and he uses the rent to settle the loan and the interest. This is the idea behind appointing a receiver. Yes. So the receiver has powers both under the CA and PCL. The receiver has powers to take possession of the property, to lease the property, to demand for money, right? To sue in the name of the mortgagor, to sue in the name of the mortgagor, and to receive profit from the property. So this is the functions or the powers of the receiver. Yes, it takes possession, acts on the property, sues on behalf of the mortgagor, repairs the property and all that. It takes care of the property, basically to make profit. And when the receiver is done making profit, there is also what? There is duties and applications of the proceed of the profits. So in applying the proceed made by the receiver pays all rents, tax, outgoings on the property first. The second is to pay the mortgage sum and the interest, pay all the mortgage ranking in priority, right? And then any commission expenses made in course of receivership, and the residue is paid to the mortgagee or anybody entitled to it. So this is the position of appointing a receiver. A receiver is a person, a third party, uninterested, that manages the property, make profit to settle the mortgage sum and the interests. The next right of a mortgagee is foreclosure. Yes, foreclosure. We'll discuss foreclosure, and finally we'll discuss right to sell. Now, foreclosure is an order of court. I want you all to know this. Foreclosure is an order of court. What foreclosure does is foreclosure terminates the mortgageor's equity of redemption. I repeat, class. Foreclosure terminates the mortgageor's equity of redemption. Remember, there is a saying, once a mortgage, always a mortgage. There is only one thing that can end this saying, and this is known as foreclosure. Foreclosure terminates the equity of redemption. It's an order of court. Listen, foreclosure is an order of court that terminates the mortgageor's equity of redemption. When an application is made, the court will make two orders. The first is the order nisi or nisi, and the second is the order absolute. Where the order is made absolute, it means that the mortgageor's equity of redemption is extinguished. The mortgagor can no longer redeem the property. The ownership of the property is now transferred to the mortgagee by virtue of foreclosure. The mortgagee becomes the perpetual owner of the property. Listen carefully. Foreclosure is an order of court that gives right to the mortgagee to have perpetual ownership of the mortgage property. When the foreclosure order is made absolute, the equity of redemption is extinguished. The mortgagor can no longer redeem. He can no longer get back that property. Yes, even when he gets the money to repay and has interest to repay the loan, as far as a foreclosure order has been made, the mortgagor can no longer redeem the property. The equity of redemption is terminated. The equity of redemption is the right that sustains the mortgagor throughout the mortgage transaction. The one that says once a mortgage, always a mortgage, right? And where this equity of redemption is extinguished, terminated, the mortgagor can no longer redeem, even when he has the money to pay. Yes, the mortgagee becomes the perpetual owner of the property. This is the effect of foreclosure, and this is one of the rights available to the mortgagee. The mortgagee can apply for foreclosure, and where it is granted, an application is made to the court for foreclosure. And when it is granted, the mortgagor's equity of redemption is terminated. The property can no longer be redeemed. So there are two orders here. The first is the order nisi. And for the order nisi, it gives a 6-month grace for the mortgagor to redeem the property. As soon as this order is made absolute, it becomes perpetual. The equity of redemption is terminated, and the mortgagor can no longer redeem, even where he has the mortgage sum and interest. This is the effect of foreclosure. The mortgagee becomes perpetual owner. The mortgagee has absolute title in the property. Yes, absolute title in the property. And this is not power of sale. This is not right to sell. It's totally different. Now, with absolute title, the mortgagee can do anything he wishes with the property. He can decide to sell, lease, even gift the property to another person. Foreclosure. Take that. Now, foreclosure can be reopened. Yes. foreclosure can be reopened. Where there is a timeous application, foreclosure can be reopened. All right, let's get to the very important one, right to sell. Yes, right to sell. Now, this is very important. You must get the principles in this right to sell. One of the rights available to the mortgagee is right to sell. Right to sell. And what are we saying in here? Right to sell the property, right to sell the security. Yes, right to sell. Right to sell is central. It applies to a legal mortgage. I repeat, it is central. It applies to a legal mortgage created by deed. Right to sell. Right to sell. It applies to a legal mortgage created by deed. So one of the rights of the mortgagee is the right to sell. Now, before the mortgagee sells the property, listen, before the mortgagee sells the property, you must know this. Two things must happen. I repeat, class. Before the property is sold, two things must happen. Number one, the power of sale must arise. Class, the power of sale must arise. And number two, the power of sale must become exercisable. I repeat, number one, the power of sale must arise. And number two, the power of sale must become exercisable. For the mortgagee to sell the property, the power of sale must arise, one. And two, the power of sale must become exercisable. I believe in your minds, you are asking now, at what point will the power of sale be said to have arisen? And then at what point will the power of sale will said to be have become exercisable? At what point does the power of sale arise? And at what point does the power of sale becomes exercisable? Yes, please, these are the two conditions. The power of sale must arise and it must become exercisable. Now, these are the circumstances where the power of sale will be said to have arisen. Number one, the mortgage is created by deed. Number one, the mortgage is created by deed. Number two, the legal due date, that's the date to repay the loan, is called legal due date. Number two, the legal due date have expired. Number two, the legal due date have expired. And number three, there is no agreement against sale in the deed of mortgage. Number one, the mortgage is by deed. Number two, the legal due date have expired. Number three, there is no agreement against sale in the deed of mortgage. These are the conditions for the power of sale to arise. So at this point, the power of sale have arisen, but it is not yet exercisable. Please, for a sale to be appropriate, the power of sale must arise and must become exercisable. So if the mortgagee sells where the power of sale have arisen, that is the legal due date have lapsed, the sale is inappropriate because the power of sale have arisen, but it is not yet exercisable. Please take note of this. The power of sale must arise and it must become exercisable. Where the power of sale have arisen only, the sale is not appropriate. The sale of the property is appropriate when the power of sale becomes exercisable. Please don't forget the application of this for the bar exams. The power of sale must arise and become exercisable. At the point where the power of sale have arisen, sale of the property is not appropriate. It may be valid, it may be valid, but the sale is not appropriate. Yes, I'll tell you when to be valid. It may be valid, but the sale is not appropriate. The sale is appropriately done where the power of sale have become exercisable. Take note of that. So the power of sale will said to have arisen where, number one, the mortgage is created by deed, the legal due date have expired, and there is no agreement against sale. Now, the power of sale will be said to have become exercisable where, number one, a letter of demand have been served. Yes, a letter of demand have been served. If you don't call it letter of demand, you call it demand notice. The mortgagee sent notice demanding for the mortgage sum and demanding for the interest. And the mortgagor has refused to pay, has defaulted for 3 months. The mortgagor has defaulted for 3 months. This is one of the grounds where the power of sale will be said to have become exercisable. Letter of demand has been sent and the mortgagor has defaulted for 3 months. The mortgagor is also in arrears of interest for 2 months. He has defaulted payment of interest for 2 months. He has defaulted payment of some principal mortgage sum for 3 months. And number 3, breach of any provision in the deed of mortgage. Number 3, breach of any provision in the deed of mortgage. Now, at this point, the power of sale will be said to have become exercisable, and a sale done at this point is appropriate. Why a sale done where the legal due date have expired only is inappropriate, because the power of sale is not yet exercisable. The power of sale must become exercisable for sale to be valid. Take note of that. Now, there are other principles revolving around power of sale, and one of them is the conduct of sale. One of them is the conduct of sale. Please, in conducting sale, that is at the point where the power of sale has become exercisable and the mortgagee is to sell the property of the mortgagor. In the conduct of sale, there is an appropriate mode prescribed by law. And this appropriate mode is known as public auction. By auction. So where the sale of the property is done by public auction, it is appropriate. The reason is this: conducting sale by public auction removes every iota of fraud in the conduct of sale. Conducting sale by public auction removes every iota of fraud in the conduct of sale. When sale is done by public auction, it's done in public through an auctioneer, auction sale. The mortgagor cannot raise an objection to the sale on the ground of fraud, because sale conducted by public auction is deemed to be transparent. That's why it is advisable to conduct sale by public auction as against private treaty. Yes, public auction is advisable against private treaty, because sale conducted by public auction removes every iota of fraud. The mortgagor cannot challenge the sale on the grounds of fraud, because it is deemed to be transparent ab initio on its face, right? So this is the issue with conduct of sale by public auction. When you're asked to write on the conduct of sale, on a question on that, you advise that sale is conducted by auction, public auction, appointing an auctioneer. Now, you must also take note of the fact that sale at undervalue is not inappropriate. Yes, where the property is sold lower than its value, it is not a ground to vitiate the sale of the property. Yes, the sale of the property will be set aside on the grounds where the mortgagor has no title from beginning. Number one, a sale will be set aside where the mortgagor has no title from beginning. Number two, fraud. On the grounds of fraud, the purchase of the property amounts to fraud. Number three, where there's evidence that the loan have been settled, that is, the loan has been fully paid and the interest have been paid. Yes, the sale would be what? Would be vitiated. The sale will be set aside. And then where the required consent has not been acquired, for example, governor's consent, the sale will be set aside. For the issue of the point of sale, that is where the sale is done at the point where the power of sale have arisen, the sale will not be set aside where the sale is made to an innocent purchaser, innocent bona fide purchaser for value. The sale is not set aside where the sale is made to a bona fide purchaser for value at this point. The sale will not be set aside, even though the power of sale has not become exercisable. Don't forget, it is inappropriate, but the sale will not be set aside, especially where the third party is a bona fide innocent purchaser for value. The sale is valid, although there may be right of action against the mortgagee. So these are the issues on the power of sale and the right to sell. Now, on the application, for application of proceed of sale, you must know this. There are 5 stages in the application of proceed of sale, and these stages must come in the sequence. There are 5 stages for the application of proceed of sale. Number 1, application simply means how the money realized from sale of the property should be used. So number 1, pay up mortgage ranking in priority. Number 1, for application of proceed of sale, number 1, pay up mortgage ranking in priority. Number 2, pay up auctioneer's fee. Number 2, pay up auctioneer's fee. Number 3, pay outstanding mortgage sum. Number 4, pay outstanding interest. And number 5, pay balance, if any, to the mortgagor or any person entitled to it. Yes, the mortgagor is entitled to balance of the proceeds of sale. So these are the basic issues we need to take cognizance of on the right of the mortgagee, especially the right to sell. Remember the issue of power of sale. It must arise and become exercisable. However, where it has not yet become exercisable and the sale is made, the sale may not be set aside where it is made to a bona fide purchaser for value. So these are the rights of the mortgagee. Let's get quickly to the right of the mortgagor and end our class at this point. Now, for the right of the mortgagor, there are 3, the first 3 I would deal with. The first 3 are number 1, legal right of redemption. Number 1, legal right of redemption. Number 2, equitable right to redeem. Number 2, equitable right to redeem. And number 3, equity of redemption. These 3 rights of mortgagor are confused by students, and I want you all to understand this now. Number 1, legal right of redemption. Number 2, equitable right to redeem. And number 3, equity of redemption. Let's start with number 1. Number 1, legal right of redemption. The legal right of redemption is the right of the mortgagor to redeem his property anytime before the expiration of the legal due date. As far as the legal due date have not expired, the mortgagor has a legal right of redemption. He can redeem the property anytime before expiration of legal due date. And by doing this, the mortgagor pays the mortgage sum and interest, settles everything before expiration of the legal due date. This is legal right of redemption. Right to redeem before expiration of the legal due date is legal right of redemption. The second one is equitable right to redeem. Now, at the point of equitable right to redeem, this is point B. At point B, the legal due dates have expired. I repeat, the legal due date have expired, and the mortgagee still has the right to redeem the mortgage property at this point. At point A, legal rights of redemption, the legal due dates have not expired. The mortgagee has legal right to redeem before expiration of the legal due date. At point B, equitable right to redeem, it comes to play after the expiration of the legal due date. When the legal due date have passed, at point B, the mortgagor still has equitable right to redeem. Please, class, this is the difference between legal right of redemption and equitable right to redeem. Legal right is point A, the right to redeem before expiration of the legal due date. Now, equitable right to redeem is the right of the mortgagor to redeem after expiration of legal due date. At the point the legal due date have expired, the mortgagor still has equitable right to redeem. Equity avails him. Yes. Now, the third one, point C, is equity of redemption. Class, equity of redemption is the sum total of the mortgagor's right in the transaction. It is equity of redemption that makes the transaction a mortgage and not sale of land. Yes, because equity of redemption says once a mortgage, always a mortgage. This is equity of redemption. Even after the expiration of the legal due date, as far as there is no foreclosure, there is no exercise of power of sale, the mortgagor still has the equity of redemption. The transaction still remains mortgage until there is foreclosure or the property is sold. So even after the legal due dates have expired and the mortgagee has not exercised power of sale, the mortgagee has not applied for foreclosure, what avails the mortgagor at point C is known as equity of redemption, the sum total of the mortgagor's interest remaining in the transaction. Yes, equity of redemption makes a mortgage transaction a mortgage transaction. The mortgage transaction remains the same until foreclosure is effected or the property is sold. This is point C, equity of redemption. At point C, even when the legal due date have expired, the mortgagee has not sold the property, the mortgagee has not applied for foreclosure, the mortgagor still has equity of redemption. He can redeem the property at any time until foreclosure is effected or power of sale is what exercised. This is the difference between legal right of redemption, equitable right to redeem, and equity of redemption. Legal right of redemption is point A, where the mortgagor has right to redeem before the expiration of the legal due dates. Now, at point B, what avails the mortgagor is equitable right to redeem. After the expiration of legal due date, the mortgagor has equitable right to redeem the property. Now, at point C, even after the expiration of the legal due date, provided that no matter how long it takes, provided that the mortgagee has not applied for foreclosure and the mortgagee has not exercised power of sale, the transaction remains a mortgage transaction and the mortgagor can redeem his property at any time until it changes by foreclosure or exercise of power of sale. And this leads us to the saying, once a mortgage, always a mortgage. Once a mortgage, always a mortgage. Class, this is equity of redemption. Now let's get to other rights of mortgagor. The mortgagor has right to strict account. Yes, I told you all, where the mortgagee decides to take possession, the mortgagee is liable to render strict account. Yes, the mortgagor has right to strict account. Number 4, the mortgagor has right to balance of proceeds of sale. Yes, it is the mortgagor's right, where the power of sale has been exercised and the money realized have been used to settle mortgage sum, settle interest, settle all expenses incurred, and there is any remainder, the right of the mortgagor is to take the remainder of the proceed. This remainder is known as balance of proceed of sale. The mortgagor has right to balance of proceed of sale. Any money remaining after settling mortgage sum, interest, and other expenses belongs to the mortgagor and not the mortgagee. The mortgagee must return it to the mortgagor. This is known as the right to balance of proceeds of sale. Yes, he has right to rent, of course. He has right to rent, although it must be with the consent of the mortgagee. Right to rent. Yes, that's why I said mortgage is transfer of interest in land, not possession. Because a property can be used to create mortgage and the mortgagor is still collecting rent. If possession is transferred, there will be no property to collect rent from. So you need to know this. Yes, right to rent, right to sue for trespass, right to defend the property. It's still his property, so the mortgagor has right to defend the property. The mortgagor also have right to lease the property, subject, of course, to the mortgagee's consent. So, class, these are the rights of the mortgagor. Now, on the final note, I would end this class on mortgage with discharge of mortgage, how we can bring mortgage to an end. Now, discharge of mortgage depends on how it is created. The mode of discharge of mortgage depends on the mode of creation of mortgage. Now, where legal mortgage is created, by assignment, demise, or subdemise. Where legal mortgage is created by assignment, demise, or subdemise, legal mortgage is discharged by deed of release. DEED is created by deed. It must be discharged by deed. And this deed is known as deed of release. Secondly, where legal mortgage is created by charge. Where legal mortgage is created by charge, legal mortgage is discharged by statutory receipt. Where legal mortgage is created by charge, legal mortgage is discharged by statutory receipt. And finally, where it is an equitable mortgage is discharged by simple receipt. Simple receipt simply means evidence of payment of the mortgage sum and interest. Now, at this point, we'll come to the end of our discourse on the topic mortgage in property law practice. This is Legal Lounge powered by E.L Everything Legal. I am Chukwemeka Philip Esq, your tutor and host. Now, our revision classes will be coming up, and you all will be made available of the dates of our revision classes for the bar exam. Stay tuned to further sections on Legal Lounge as we convene next week, Saturday, by 7 p.m. Have a good evening, everyone.